first?
Nichols.
Okay, give me a second here.
Okay, are you Rick Nichols? Rick, there on the W. Evans screen?
Yes.
Yes, sir. All right. Case number, two cases here involving the same defendant. Case number 20CR12 and 18CR196. Both style State of Ohio versus Rick J. Nichols. This hearing is being conducted by Zoom. Mr. Nichols is appearing remotely from the counseling center. Representing him, appearing by Zoom from his office is William Armstrong, also representing the State of Ohio, his assistant prosecutor came. The defendant entered pleas of guilty in case number 20CR12 to failure to appear, a fourth degree felony, and case number 18CR196 to aggravated possession of methamphetamine, fifth degree felony. This matter is before the court for sentencing after the court ordered pre-sentence investigation, which I have reviewed. Now, Mr. Armstrong, your client, both stipulating to having this hearing remotely rather than his personal appearance in the courtroom before the court.
Yes, ma'am.
And you're in agreement with that, Mr. Nichols?
Yes.
All right, thank you. Now, Mr. Nichols, since you're not in the courtroom sitting with your attorney, if you at any point need to talk with him, I can put you and him into a breakout room, which means the two of you will be on the screen talking to each other privately. No one else will be able to see you. Okay?
Okay.
Right. Now, have each of the attorneys had an opportunity to review a summary of the PSI?
They have.
I have not yet.
Okay. All right, Pete, you're prepared to go forward.
Yes, ma'am.
Mr. King, anything on matter of sentencing?
Only ones containing the plea agreement, Your Honor.
All right. Mr. Armstrong?
I would ask the court to follow the plea agreement in place of Rick on community control. As the court's aware, I believe, and he'll correct me if I'm wrong, I think this is maybe his last day or yesterday was of his inpatient residential treatment. I think he goes into some kind of transitional control after this. When I last spoke with him in person, he was still in jail. Obviously, Your Honor, he looks a lot better. He's doing a lot better than he was a few months ago. We'd ask the court to take that into consideration.
All right. Mr. Nichols, anything that you would like to say?
No, sir. Like, since being in treatment, I did wanted to mention something that I met somebody here that was on your drug court. I know my deal was the community control, but like I want to keep doing the next right thing. I think that I've heard a lot about your drug court you have there, and I didn't know if maybe that was an option in this situation or not. I know I talked to Armstrong about it. I know it's a lot stricter than just probably the community control, but I feel like it's something that would be more of a benefit to me than it would be, because I just want to keep, I want my life back. I don't want to I want to keep doing the next right thing, and just having that extra, I think would be a good thing for me, like the deputy back. So I just figured I would mention that. I didn't know how that goes. And I thought you that was the only thing that I had to talk to you about.
Okay.
Your Honor, if I may, we did speak about that, and I told him very admirable of him. I said it's a great program. It's a lot stricter, but if you help with employment and jobs and housing, and he did back off for wanting to submit that to the court.
Okay. Are you going into transitional programs there at the counseling center? Okay. And what? Let's see. I forgot. Where do you actually live, Nichols?
Pike County. I live in Pike County.
Okay.
I'm in Adams County right now.
Right. Okay. Well, so you are in Tony County. Okay. Anything else?
No, sir.
Okay. Well, the court is going to order you to be put on 3 years community control under these conditions, which we'll go over in a minute. I will refer you to the drug court coordinator for evaluation. You you do have a 20-0 RAS, which doesn't meet the criteria. Although this is your first felony convictions, I believe, is that correct?
Yes, sir.
Although I do see you have a pretty extensive misdemeanor record and a lot of history in terms of that. So I'm going to go ahead and refer you to the drug court coordinator for evaluation for the drug court docket. But in the meantime, and in the event that you decide you want to apply for that, because you have to ask for it, you have to be screened and meet certain criteria, and then be recommended for that, and then the court will review that. And if I do, then we can transfer you over to that docket. But for the time being, you're under community control, supervision for a period of 3 years. Under these conditions, you're to obey all laws of all jurisdictions, conduct yourself in law-abiding manner at all times, you report when and as directed, and be truthful in all statements you make to the probation department. You are to keep them informed of your residence and place of employment at all times, may not change either without prior permission. Not leave the state of Ohio at any time without prior written permission. May not enter upon the grounds of any correctional facility, nor communicate with or attempt to communicate with anyone who's an inmate in this facility without prior written consent of your probation officer. You may not, because of your conviction for the drug offense, felony, you're disqualified under both federal and state law for owning, possessing, abusing, or having under your control a firearm. And that's also a condition of this order. Also, you're prohibited from having ammunition or dangerous ordnance or any other weapons of any type. And you're not permitted to purchase, possess, use, or have under control any kind of a controlled substance, drug abuse, CBD, oil, creative, or any variant or analog of any controlled substance that has effects or similar controlled substances of drug abuse, nor any device or instrument that can be used to administer those or prepare the administration unless you have a prior legal written prescription, and you must provide a copy of that to your supervising officer within 24 hours of receipt. You are to submit to drug testing when and as directed. May not purchase, possess, use, or have under control any kind of alcoholic beverage or be present in any place where the sold being consumed is otherwise lawful. You're not to associate with anyone who is a co-defendant in this case, if there are any, or any person that has a criminal record, member of gang or a criminal group, or any person that has in the past with the future until you commit a criminal offense, or to violate these conditions unless approved in writing by your supervising officer. That apply to family members of the those who are residing with immediately before the commission of this offense. After the date of this order, you may not marry or establish cohabitation in a non-law marriage-type relationship with another person without written permission. You must report any contact with law enforcement or any arrest, citation, conviction, or other charge of violating the law not later than that next business day after that occurs. You must provide your supervising officer financial information records so your ability to pay any fees and costs to be reviewed. If you're referred by probation department for any further evaluation or assessment for any kind of other type of programming, counseling, training, education, etc., you'll submit to that. If there's a recommendation to complete that training or programming, then you're to enroll and successfully complete that. You're paid court costs to make payment arrangements to do that. Will be required to successfully complete your substance use disorder residential treatment counseling center and any recommended aftercare. There will be no fine or imposed, and there will be no suspension imposed in the 18 CR 196 case. Now, you're also going to pay the court costs, which has been granted execution order. If you don't make payments on those, in addition to being a violation of your commission control, you're required to do that under conditions. Then the clerk would try to collect that through various other means, including letter of bank accounts, wages, earnings, other assets you may have. If that doesn't collect it, then the court could order you to do community service, give you credit for each hour you work, and now the rate set by the court each hour you work and reduce your judgment by that amount until paid. Now, in the event that it's alleged that you have failed to comply with these conditions, probation department will file a written notice of that with the court, give you a copy, and then you'll be entitled to have a hearing and be represented by an attorney. If the outcome of that hearing is that you have failed to comply, then the court would revoke your community control and then sentence you to 26 to 12 months and 18 CR 196 finding $25, 26 to 18 months and 20 CR 12 and finding $5,000. And those could be ordered to be served consecutively for a total of 30 months. In the event that that would occur upon completion of that sentence, the Parole authority could, as part of the sentence, decide to put you in post-release control for a period of 3 years, meaning, 2 years, meaning you'd be supervised by a parole officer in the terms that they set. And if during that period of time they determine that you failed to comply, then they could return you to prison, even though you served the entire term already imposed by the court, for an additional period of up to 9 months for one violation, but there's a cap or limit of half of whatever prison term is imposed for all violations. But if your violation is a felony, then in addition to whatever sentence the judge in any case could impose upon you, the judge would also sentence you in this case to an additional period of 1 year, or whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that must be served consecutively to sentence in the new case. All right, that completes the sentencing. You're no longer in pretrial supervision under those conditions, and will need to be reporting to probation. Mr. Bolton, is he going to need to call in to somebody, or will they be reaching out to him? How's that going to work?
We can contact the Nerd Counseling Center, get something set up.
All right, very good. All right. Have any questions then, Mr. Nichols?
No, sir.
All right, and the drug court coordinator, she's on this hearing. She'll be reaching out to you as well. All right, thank you.
Thank you, sir.
Let's see.
Moore is
Joshua Moore. Who is it that's at the jail?
Hurley. Well, we have a long list.
Okay. Where's Mr. Moore?
He's supposed to be calling in from in person. He's supposed to be in
He's
person.
one supposed to be in person.
Yeah.
All right. I will call that case in.
Okay, hang 1 second, please. Joshua Moore, Mr. Armentrout on the record.
All right, case number 21-CR-144, Stable House versus Joshua Moore. This is Mr. Moore is scheduled to appear before the court today at 1 o'clock in person for a sentencing hearing. He is not present in court, and we not have him on a Zoom call either, and I believe he's either of those individuals. And Mr. Armentrout, have you heard anything from Mr. Moore lately?
Not since the plea hearing, Your Honor.
All right. Mr. Arjima, have you heard anything from him?
No, not since the plea hearing. He called to schedule his PSI, reschedule it.
You failed to come in either time.
Correct.
All right, okay. All right, court will issue a ticket for his arrest, and case will be put on an active docket. He'll be held without bond. All right, do you represent Mr. Monroe, or let's see, who are you that's on Monroe Street?
Joshua Holmes.
Okay, you represent him, Mr.
Well,
Armstrong?
that's the one from Gallia County.
I got Robert Hurley.
Okay.
We got Shannon Wilson.
Jail for plea.
Okay.
Shannon Wilson.
Okay.
Your Honor, I have Mr. Combs.
Mr.
All
Combs is,
right. Okay, you
I
have
have
Mr.
Mr.
Combs is the one that's in Gallia County, Your Honor.
Oh, okay, yeah, Mr. Combs is not available. He is serving a sentence for domestic violence in Gallia County. So I continued that case and put a case out for him. And when he gets done, there's a holder on him, and then we'll bring him back out then.
Okay, I believe that's him on the screen there, just so you're aware.
Yes.
Oh, it is? Oh, I didn't know that. Okay, so which one is he? He's on the road? Oh, okay. Well, we didn't know that you had been invited to be on this, so I mean,
It's an evidentiary. So,
this is an evidentiary hearing.
yeah, you said you wanted him
And it's
here.
supposed to be in person.
Yeah, you said you wanted him here, so
Yeah.
the cake file went back downstairs this morning.
All right, we're gonna have to hold up on that because I gotta get the case file. We didn't, okay, Mr. Combs is on the phone. So, we'll go get the file.
Okay.
All right, we'll go ahead and do,
Wilson.
The jail will remove the unmute there, so I can
Shannon,
identify who that is.
Shannon Wilson is Mr. Armentrout's last one away from the jail. Then we've got
What's your name, sir?
That's Brandon Pettigrew.
Okay, Brian. Okay. All right. Shannon Wilson is,
she's
that's Bill's.
Bill's, yeah.
All right.
And Hurley is the first one in the jail out there he's Bill's as well.
This is that one.
Yeah.
They don't have the same order.
Well, we shifted it just like 3 times this morning.
Alright.
Is Shannon Wilson on there?
Yeah, but we got Pettiford on the screen, so try to find his spot.
Is she there on your screen?
Mr. Pettiford, yes, sir. 19 CR202.
She gonna do Pettiford? Or who you gonna do? Who are you calling?
Pettiford.
Okay.
Alright,
On the record, Pettiford.
is case number 19 CR202, State of Iowa versus Brandon Pettiford. Mr. Pettiford is appearing by Zoom from the jail. Attorney is Dennis Kirk. Attorney by Zoom also appearing on behalf of the state is Attorney Assistant Prosecutor King. This is before the court on an evidentiary hearing, alleged violation of probation. Now, Mr. Kirk, well, the defendant was advised of his notified of the alleged violations came back in November 29th, 29th or 30th, somewhere around there. And Mr. Kirk was appointed to represent him, and now we're set for hearing today. Mr. Kirk, we have an opportunity to review the allegations with the client.
I have reviewed the allegations with my client, Your Honor, and advised the book's right to a hearing. He does wish to waive that hearing and enter an admission into the violations.
Right. Now, do you and your client both agree to conduct this hearing remotely by Zoom and waive any in-person appearance in the court?
Yes, Your Honor.
Do you agree with that, Mr. Pettiford?
Yes, sir.
All right. Now, the allegation, well, you were put on community control on February 21st, 2020, prior to possession of methamphetamine. There was an allegation filed on February 29th that last year that you had failed to comply with Rule 2. You had reported since July of 2021. Rule 7 that you admitted to using methamphetamine, and THC under guideline 23. 21 and tested positive on those for those of 29. And then it says that you had not completed or attended any active care or provided completion of attendance of active care. Violation Rule 20. That was signed by Officer Kelly, who's also present for the hearing. All right, now, Mr. Pettiford, in the event you're found to have committed this violation, I can do one of 3 things. I can continue your duty control under the same conditions previously ordered. I can continue with additional conditions I think are appropriate. And the third and most serious is I can revoke duty control, send you to prison for between 6 and 12 months, and fine you $2,500. Do you understand the consequences of the violations if they're proven?
Yes, I do.
Do you understand you have a right to have a hearing in which the state would have to present testimony through witnesses, and your attorney could cross-examine those for you, and you could present evidence on your own behalf if you wanted to? Do you understand that?
Yes, sir, I understand.
Does anyone promise you anything or direct you in any way against you to make this submission here today?
I do, yeah.
Okay. All right, do you have any questions then about the violations and possible consequences if it's proven that you have failed to comply?
No, sir, I don't.
And is it your decision to admit to the allegations that were filed on November 29th of 2021 that I just went over with?
Yes, sir, Your Honor.
All right. All right, is there anything from the probation department or the state regarding disposition in this matter?
Thank you, Your Honor. It's clear that this defendant has an ongoing substance use issue. He has not been convicted of any new criminal offenses while on supervision. So based upon that, the state and probation department would ask that he be continued on community control in order to complete STAR relapse. It's my understanding that there's a bed available for the defendant at STAR on January 19th. Thank you.
And Mr. Armstrong?
Mr. Kirk.
Thank you, Your Honor.
Or Mr. Kirk, I'm sorry.
Thank you, Your Honor. We would ask the court to also continue the community control. When I met with Mr. Bedford out of the jail, he advised he feels he's hit rock bottom. He feels like he's got to turn a corner here, that this lifestyle is just not working. And he advised me that he would be open to any type of treatment in order to turn the corner here. As the state noted, there's no new felony or even misdemeanor charges. The basis for the main violation is just failing to appear and using drugs again. And I think he's at this point now where he wants to try to turn the corner. So we would ask the court to continue community control and grant some form of treatment or the STAR relapse program if that's appropriate in order to assist him in this effort to recover.
Mr. Kelly, have you discussed this with Ms. Sturgill about possible SUD treatment at a residential facility other than STAR? You know, STAR is not totally focused on drug SUD, and I'm thinking that the counseling center or recovery or Massey House might be appropriate.
No, Your Honor. We just discussed the STAR program. I can get with her and see if she could recommend another facility.
All right, Mr. Pettiford, anything you'd like to say?
Yes, sir, there is. So I know that I've made some mistakes here in the last year or so. Like my attorney said, I have hit rock bottom, and I don't feel like I would be able to get what I need out of the relapse. If possible, like the drug rehab would be the best bet for me. So I can use the skills that I've already obtained from STAR, and I can use them to build what I'm going to learn in the drug rehab facility. And that's it.
All right, well, it's the order of the court that should be referred to the drug court docket for evaluation. It's also the order of the court that community control will be continued. It'll be extended for 1 year. And you're going to be required to successfully complete a substance use disorder treatment program and recommended aftercare. I'm going to, and I prefer that not be STAR relapse because that's, I don't think there's enough, it's only a 60-day program and that's not enough focus on the SUD issue. You'll remain in jail until there's a bed available, and the probation department will contact the treatment coordinator and the drug coordinator about a placement as soon as there's a bed available. Court will order you to be released before that to successfully complete that. And then in terms of whether you want to be in the drug court or not, that's something you have to choose. I'm not sure you're qualified. There have to be certain things that confirm that you're eligible, and then whether or not you want to apply. It's not going to refer you there, doesn't mean you have to do it, but it is one option. All right, is there anything for the counsel?
Yeah, you're right.
All right, thank you. Shannon Wilson, bring in Shannon Wilson, officer.
Should be an outside.
Your Honor,
Yeah.
while you're doing the next one, could I have a breakout room with Josh Combs, the one that says memorandum?
Okay, yeah, all right. Mr. Combs, we'll put you and him, Mr. Kirk, into a breakout room here. I have your file now.
Okay, thank you. Your Honor, Shannon Wilson is,
Not in custody.
Yeah.
not in custody.
Oh, okay, well, we'll have to wait then, we'll go whoever's next in the jail.
Hurley is next one for
Who is it?
Hurley for
Hurley, all right.
Robert Hurley for Mr. Armentrout.
Okay, Mr. Combs is in the Monroe screen, okay. All right. All right, that should take you there. Should be something that pops up that says you're to join. There we go. All right, and who do we have in the jail now?
Robert Hurley, Your Honor.
Mr. Hurley, okay. That's your time?
Yes, yes.
On the record for Hurley.
Recording in progress.
All right, this is case, excuse me, case number 21 CR 190, State of Ohio versus Robert Hurley. You are Robert Hurley, appearing from the jail.
Yes, sir.
All right, this hearing is being conducted by Zoom. Mr. Armentrout as his attorney. He's appearing by Zoom from his office, representing the state from his office, by Zoom is Mr. King. The defendant is charged with assault on a police officer, 2 things. Now, Mr. Armentrout Jr. and Clyde both stipulated this hearing being conducted by Zoom rather than in person in the courtroom hearing.
Yes, Your Honor.
You agree with that, Mr. Hurley?
Yes, sir.
All right, then. Now, Mr. Hurley, I've been presented with a plea of guilty form, which I'll hold up to the screen there to the camera. You see that with your name and case number. It says plea of guilty.
Yes, Your Honor.
All right, this is a 3-page document the prosecutor's office prepared from a form in their computer. And on page 3, there's a signature line, and about a third of the way down, there's a sentence that reads, "I enter this plea voluntarily." Immediately below that appears to be the signature of Robert Hurley. I'll hold that up to the camera and ask you if that is your signature that I'm showing you.
Yes, Your Honor, it is.
When did you sign this document, Mr. Hurley?
It was like 3 weeks ago.
Okay. And there at the jail, signed it?
Yes, Your Honor.
Was your attorney with you, and did he go over it with you before you signed it?
Yes, Your Honor, he did.
And when you signed it, did you understand that it's an agreement to plead guilty, which means there won't be a trial? The next step in your case would be a sentencing hearing.
Yes, Your Honor.
And have you had enough time to fully consider this matter before making this decision?
Absolutely.
And do you feel that you've been rushed or pressured in any way into doing this?
No, Your Honor.
And you've had 3 weeks since you signed the agreement. Is it something you still want to do?
Yes, Your Honor.
And you entered into the agreement to plead guilty voluntarily.
Yes, Your Honor.
And the agreement states you're going to withdraw your not guilty plea, plead guilty to count 1, assault on a peace officer under 2903.13a, the Ohio Vice Code, a 4th degree felony. It further states that you understand that the maximum penalty for that prison term is imposed would be 18 months incarceration. The minimum could be imposed of 6 months, and any amount in between. There could also be a fine of $5,000. You understand that?
Yes, Your Honor.
And are you currently facing any felony charges in any other jurisdiction?
Yes.
Where at?
Greene County.
Right. If you are convicted in this county and sentenced to prison, and if you're convicted in that county and sentenced to prison, then those sentences could be served consecutively, meaning one after the other. So do you understand that?
Yes, Your Honor.
And are you on probation, community control, parole, or post-release control for a felony from any jurisdiction?
No, Your Honor.
Now, under the law, if you are convicted of this offense, and sentenced to prison, once you serve the prison term, the adult parole authority could, at their option, place you under what's called post-release control supervision for a period of up to 2 years. And that means you would be supervised by a parole officer the terms they set. And if during that period of time they felt that you were not complying, then they would file a written notice of that with the court and give you a copy. I'm sorry, I'll get that myself. If they found that you did, they have their own proceeding. And if they found that you did, then they can return you to prison, make you serve an additional period of up to, in this case, half of your prison term for 1 or more violations. But if you commit a new felony, then an additional member sentence a judge in a new case can impose fine. The judge could also sentence you in this case to an additional period of 1 year or whatever time is left on that term of post-release control, whichever is greater for committing a new felony on the post-conviction supervision in this case, post-release control. You understand that?
Yes, Your Honor.
Now, I'm not required to sentence you to prison for this offense. And so I could, instead of sending you to prison, impose what's called community control or probation. What that means is instead of going to prison, you'd be put under the supervision of a probation officer in the term set by the court for a period of up to 5 years. And if during that period of time the probation department felt that you were not compliant, they would file a written notice for a certain copy on you. There would be a hearing. You'd be entitled to be represented by counsel. And if the outcome of that hearing was you failed to comply, then at that time the court would revoke community control and then send you to prison for 18 months to fine you $20,000 or $5,000. Do you understand that?
Yes, Your Honor.
Now, the charge alleges that in count 1 alleges on or about October 15, 2021, Highland County, Ohio, you did not only cause or attempt to cause physical harm, control, the J. Beatty, The peace officer is defined in ORC section 2935.01, the revised code, while in the commission of his official duties, in violation of section 2903.13A of the Ohio Revised Code. So that's the charge of assault on a peace officer with the 4th degree felony, the penalties I just described. Now, Mr. Hurley, do you understand what it is the state has charged you with doing, what, when, where, and how they allegedly did it?
Yes, Your Honor, I do.
And you understand the possible penalties to that effect?
Yes, Your Honor, I do.
Have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, and possible defense you might try to raise in trial, and possible outcomes of the trial with your attorney?
Yes, Your Honor, I am.
And are you satisfied with his advice and confidence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Have any threats been made against you to plead guilty here today?
No, sir.
And the agreement states on page 2, there's a couple of lines that are printed in bold and underlined near the lower part of the page. It says, defense shall enter plead guilty to count 1, state will dismiss count 2, state defense joint recommending community control of substance abuse treatment. Is that your understanding of the agreement?
Yes, Your Honor.
Does anyone promise you anything other than that to get you to plead guilty?
No, sir.
Now, under the law, the matter of sentence is up to the judge, not the parties. So even though there's an agreement from both sides that the sentence should be community control or probation, I don't have to follow that recommendation if you plead guilty. Once I've heard all the information that's submitted, if I decide that's not the correct sentence, I could impose a prison term between 6 and 18 months, as well as fine you $5,000. You understand that?
Yes, Your Honor, I do.
Mr. King, the state assaulted with the 2 officers in this incident and made their agreement to this disposition.
Yes, Your Honor.
Right now, do you hold any kind of a license or certificate from any state agency or group that regulates professions like nursing assistants, CNAs, vet techs, etc.?
I'm not sure if this qualifies, but I'm an ordained minister.
A what?
Ordained minister.
Yeah, I believe it does. So I would, the clerk would have to send a copy of the conviction to the regulatory authority for that, and then they would decide whether or not there would be any, if there is even just whatever proceeding. I'm not familiar with that group. I know you have to get a license to do that. So anyway, not that we're saying that they should do anything, it's just that under the law, the court is required to send a copy to any state-regulated profession. So that means that if you're convicted, there could be some action taken on your license. I don't know that there will be, but there could be. You understand that?
Yes, Your Honor, I do.
Now, you have certain constitutional rights you must understand before I can accept the plea from you. First, you have the right to have counsel. Mr. Armitage is appointed to represent you, not for the purpose of simply trying to work the case out, but to provide any defense that be available to you under the law that you wish him to provide. So, if you decide that you do not want to do this, that you would rather defend against the case, then he will defend you and continue to represent you, including a trial, if that's what you want. Do you understand that?
Yes, Your Honor.
All right, now, did I ask you if you have any other charges pending against you in any other jurisdiction right now?
Yes, Your Honor.
All right, because I see from the discovery that there was a plea in looting in 2021 in Greene County. Is that case still pending, or has that been taken care of?
That's taken care of.
Okay, so what happened with that? Are you convicted, or was it dismissed, or what?
It was, I pled out to that charge.
A felony?
I believe it's misdemeanor.
It was a misdemeanor.
Okay, all right. And there was also possession of controlled substance also pending, and has that also been taken care of?
That's what I was referring to.
And not a felony?
It is, Your Honor. That case is pending.
Okay, that's the one that's pending that, okay, all right.
Yes,
So I just happened to take a look at the discovery here while I was talking, and I thought I'd better cover that. All right. Now, you have a right to have a jury trial in this case, Mr. Hurley, in which 12 people will be selected from a group of citizens that reside in this county who are summoned for jury duty on your trial date. After they are selected, the evidence will be presented, and then they will be instructed on the law, and they will decide by unanimous verdict, meaning all 12 have to agree, as to whether or not the state proved the case. If you didn't want to have a jury trial, but you didn't want to plead guilty, you could waive your right, which means to give up the right to have a jury trial, In that case, you would have what's called a court bench trial, meaning that it would be the judge will hear the evidence instead of the jury. The judge will apply the law, and the judge will decide whether or not to state proof or guilt or proof beyond reasonable doubt. You understand that?
Yes, Your Honor.
And you have the right to confront the witnesses against you and cross-examine through your attorney in open court. What that means is that witnesses against you have to come into court, testify in front of you and your attorney and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. And the purpose of that is to bring out evidence that helps on your side of the case. Do you understand that?
Yes, Your Honor.
Right, under the Constitution, you have the right to use the power of the court to compel force witnesses to come into court to testify for you, just like the state. So if you have witnesses you're uncertain are going to come in voluntarily, your request for court order is called a subpoena. That forces those people to come to court to be able to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come into court to testify against you. You understand that?
Yes, Your Honor.
In the Constitution, you have the privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't, you decide. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person. No one's even allowed to comment about it except in one situation. That is, if there's a jury trial and you don't testify, the judge instructs the jury that because that is the right, they cannot consider it for any purpose. Do you understand that?
Yes, Your Honor.
All right, now under the Constitution, you're presumed innocent of this charge until proven guilty by the state of Ohio by proof beyond reasonable doubt on every essential element of the offense charge. So what that means is that the burden of proof is on you to try to prove you're not guilty because you've been charged. In fact, under the law, you don't have to put on any evidence at all in your defense. You may, but you're not required to. Whether you do or not, the burden of proof will remain upon the state to prove your guilt by proof beyond a reasonable doubt on every essential element of the offense charge, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, Your Honor.
Now, originally, you entered a plea not guilty to this charge. That denied the allegation, denied you committed any crime, and exercised and revoked all the rights I just described. You change your plea from not guilty to guilty. That is the opposite of not guilty plea. The guilty plea admits allegations in the indictment, admits that they're a crime, that you're the one committed that crime. And that plea waives, gives up all the rights that I just described for you here today, except your right to have an attorney, because you always have the right to have an attorney no matter what you plead. But with that exception, your plea of guilty waives, gives up the right to have a jury or court trial, waives, gives up the right to confront the witnesses against you and to cross-examine through your attorney. Your waives, gives up the right to use the power of the court to compel and force witnesses being court to testify for you, just like the state. Your waives, gives up your privilege against self-incrimination because by saying you're guilty, that's what's used to find you guilty. And it waives, gives up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. It also waives, gives up your right to file an appeal of any alleged violations of your rights you feel could have occurred up until this point in the case. Now, if you're sentenced to the maximum sentence or under certain circumstances, it could be appealed and have to be filed in 30 days of your sentencing after being filed. And finally, it waives, gives up all the rights that it also waives, subjects you to be sentenced immediately by the court. It doesn't waive that, but now, do you understand all that?
Yes, sir.
And are you a U.S. citizen?
Yes, sir.
And you entered in this plea voluntarily?
Yes, sir.
All right. Then, do you have any questions you'd like to speak to your attorney about before we go any further?
Yes, Your Honor.
Okay, you'd like to be in a breakout room with him?
Please, sir.
All right. I need to close that room. All right. Open the new one. For some reason I can't get that first one. There we go. There we go. All right, I'm going to send you the room now. There should be a cursor comes up on the screen. Click join, and then when you're done, click leave. Okay. All right, go ahead and put us on pause on this case. We'll go to Mr. Holmes.
Okay,
Okay, case number 20 CR 87, State of Ohio versus Joshua Combs. Mr. Combs is appearing from video from the Downey County Jail. His attorney is Dennis Kirk. He is appearing. This is appearing being done by Zoom, and appearing for the state as the assistant prosecutor King. The defendant was originally convicted of aggravated possession of methamphetamine and third-degree felony, and he was charged with a violation of that. Was notified on December 1st, actually of ILC, which is intervention with conviction. He was placed on that instead of not convicted. Then the court appointed Mr. Kirk and set the matter for a hearing on January the 6th today, and that's the conclusion before the court. Now, like I said, we found out that Mr. Combs is in Downey County Jail, and so we were going to continue this, but since we didn't notify the jail, they've got inside in that Mr. Kirk, if you and your client are prepared to go forward, we will go ahead and go forward here with this hearing if you wish. You're muted, Mr. Kirk.
Sorry.
I did meet with him in a breakout room, and I believe we are prepared to go forward.
All right, is he going to admit the violation, or does he wish to have a hearing?
He does wish to admit to violating the intervention lieu conviction.
All right. And Mr. Combs, you do have a right to have a hearing on those allegations that were filed against you that I notified you of back on the 1st of December. And that means that the state had to present evidence and proof to the court's satisfaction you committed these violations. In the event that it's proven that you did, then the court will terminate you from your intervention lieu program, and you'll be found guilty, and then the matter will be set for a hearing on sentencing. I'll order a pre-sentence report, and the matter will be set out about 30 to 40 days for sentencing. And you do have a right to have your attorney cross-examine the witnesses and to try to bring out evidence to your side of the case. You can also present evidence on your behalf that contests the accuracy of the allegations. Now, do you understand the right to have a hearing in this matter, Mr. Combs?
The first one's speaking to me. I'm on the Monroe.
Pardon?
The first one's speaking to me. I'm not that person. I'm on the Monroe.
Your Honor, I think Mr. Wilson needs to mute his feed. We're getting a lot of feedback.
Yeah, we can't hear.
I thought the man of the Monroe is Mr. Combs.
You're correct.
Yeah.
Mr. Wilson was making noise. He muted himself.
Oh, okay. Okay. Now, you are Mr. Combs, right?
Yeah, right here.
Okay. Did you hear everything I explained to you a moment ago?
No, I'm
All right. Not your fault. I could hear the feedback, but I didn't realize it was interfering with that. Okay. You have a right to have a hearing in this matter in which the state would be required to prove that you have committed the violations of your intervention program. If you recall, you were put on intervention and you had pled guilty, but you were not found guilty, and the case was stayed while you were participating in this program to see if you could complete it or not. You have a right to have your the state prove the case by putting on evidence. You can have your attorney cross-examine them to try to bring out evidence to help your side of the case. You also have a right to present testimony on your own behalf if you wish to. And if you're not prepared to go forward and you wish to have a hearing, we will continue this hearing to give you time to, since Mr. Kirk was able to speak to you here this afternoon. Now, in the event that you're found to have committed these violations, whether you admit them or whether it's proven through an evidentiary hearing, what that means then is that you will be terminated from the intervention program. You will be found guilty. I'll refer the case for a pre-sentence report to the probation department. We'll send your sentencing out in about 30 to 40 days. This is a 5th-degree felony, and so if you do admit to that or are found to have violated it and are found guilty, you could be sentenced to a term between 6 to 12 months, fined $2,500, and have your license suspended for 6 months to 5 years. Or you could get community control, which is up to 5 years of supervision by a probation officer under the terms set by the court. You understand that?
I thought it was a fifth degree FI.
It is 5th-degree felony, 6 to 12 months in prison, fine of $2,500, and a 6-month to 5-year license suspension.
Okay. I mean, I thought it was an F5, not an F3.
It is an F5, that's what I said.
Oh, I'm sorry, I can't read. I'm sorry.
Okay, 5th-degree felony, 6 to 12 months, $2,500 fine, and a 6-month to 5-year license suspension is possible.
Okay.
Okay? All right. Do you have any other questions?
No.
All right. Has anyone promised you anything or threatened you in any way to get you to make these submissions?
No, Your Honor.
All right. Then do you admit the allegations that were filed against you on the 1st of December that I went over with you at that time?
Yes, Your Honor.
Okay. All right. Well, the court then will find that the defendant admits to the violation, and the court will terminate him from the intervention program. He is found guilty of the 5th-degree felony of aggravated possession of methamphetamine. The court will order an updated order of pre-sentence report with an assessment for substance use disorder and mental health treatment, if appropriate. And sentencing will be set for. How long are you in jail for in Downey County? I was told, I believe you're serving a 6-month sentence?
Yeah, the May 23rd.
Okay. Okay, we'll set the sentencing hearing for March the 2nd at 10 a.m. And that may be by Zoom or maybe in person. If it's in person, we'll have to have a warrant sent to have you removed, draw back here to that. But I'll have to make that decision once I take a look at the report, and we'll notify everybody a few days before then. All right, thank you.
Your Honor, just so that the probation department's aware, his charges are out of Gallia County, but they do not have a jail that can house people for sentencing. So he's in the Monroe County Jail. So any contact between probation and him would need to be through the Monroe.
Oh, okay. That's why I said Monroe. Okay, I thought Monroe was the name of an officer. Okay.
No.
All right. All right.
Thank you.
Thank you.
All right. Now, Mr. Combs, we did go ahead and order the capias to issue, simply put a holder on you, so if you get out of jail there, you'll be brought up here, and then we would deal with the matter of bail at that time.
All right.
So I think it doesn't sound like you'll get out, but in case it happens, that's what's going to happen, okay? All
I'm
right.
sorry, right?
All right, thank you.
Back to Hurley.
Yeah. All right.
All right, thank you, Your Honor.
Right. Let's see, now. Did we finish early?
No, we did not. They went to the breakout room.
Oh, that's right, he was back in the breakout.
Hurley with Army
Okay, we're
truck.
back on record on the Hurley case. All right, Mr. Hurley, you've had an opportunity to talk to your attorney. You ready to go forward then?
Yes.
All right. Okay, we're still going forward with the plea then, Mr. Armstrong? All right. Okay, now, I believe that what I indicated, I advise you both of constitutional rights, and I'll just go back here and pick out where I may have already said this, but I'll repeat it just to be safe for the record. Originally pled not guilty to the indictment. The indictment denied, that plea denied you committed any offense, and it invoked all the rights that I just described for you. If you change the plea to not guilty, from guilty to not guilty, not guilty to guilty is the opposite. It does, and it does waive all the rights of a claim except the right to counsel, which you always have. It also subjects you to being sentenced immediately by the court. That was, of course, the decision, and it would also waive you of any right to file an appeal, which you could have had at this point. But if you are sentenced to a maximum sentence for under certain circumstances, you can file an appeal within 30 days. And a plea of guilty would waive your right to a jury trial, front witnesses, open court, cross-examine for your attorney, to subpoena witnesses to come to court to testify on your own behalf, same to the state, to your privilege against self-incrimination. Since you say you're guilty, that's what you find you guilty. It would also waive your presumption of innocence, because say you know the state doesn't have to do it. You understand all those things?
Yes, sir.
And you are a U.S. citizen.
Yes, sir.
Now, you understand the plea agreement?
Yes, sir.
And you understand that the recommendation of committee control is not binding on the court?
Yes, sir.
You understand the charge and possible penalties?
Yes, sir.
You understand the constitutional rights I've explained?
Yes, sir.
And you understand the plea of guilty, what it means, what will happen if you enter here today?
Yes, sir.
All right, do you have any questions about anything else that's been explained here today?
There.
So, then are you, is it your decision to voluntarily enter this agreement, withdraw your not guilty to count one?
Yes, sir.
And as to the charge which alleges that on or about October 15, 2021, Highland County, Ohio, you did knowingly cause or attempt to cause physical harm to Patrolman J. Beatty, a peace officer, defined in RC section 2935.01 on the commission of official duties. Violation section 3.13a. Charge of assault on a peace officer, a fourth-degree felony, carrying possible prison term between 6 and 12 months, or 6 and 18 months, and a fine of $5,000. How do you plead?
Guilty, Your Honor.
Thank you. The court finds that on this date, open court, defendant was advised of all his constitutional rights, made no intelligent voluntary waiver the same pursuant to Article 11. Please accept the order filed. Defendant is found guilty of the offense as charged. The court orders count 2 to be dismissed. Court refers the matter for a pre-sentence investigation under the same bond, and the court shall include an assessment for substance use disorder treatment and or mental health. And the matter will be set for sentencing on February 17 at 1 p.m. Is there anything further from counsel?
No, Your Honor.
All right, thank you.
Shannon Wilson is Mr. Armentrout's last one.
Wilson is, he's not in custody.
Shannon Wilson, no. That's his last one for the,
He is on the screen.
just want to go on and, case
All right,
11.
all right, Mr. Wilson.
Yes.
All right, we'll go ahead and call your case then. Okay, this is case number 21 CR 151, State of Ohio versus Shannon Wilson.
Somebody's mic.
Mr. Wilson, I think we're getting a little feedback there. Can you hear me okay?
Yeah, I can hear you.
Okay. All right, I don't know if you have a radio or something on in the background?
No, I don't have nothing on.
Okay, it just must be reverberation, all right. Now, this hearing is being conducted by Zoom. Mr. Wilson's appearing by video through Zoom. His attorney is William Armentrout, and he is present also by Zoom from his office. Assistant Prosecutor King is appearing from his office. Mr. Armentrout, you and your client both agreed to the hearing being conducted by Zoom remotely rather than in person?
Yes, Your Honor.
And Mr. Wilson, you're in agreement with that?
Yes.
All right. The defendant is charged with 2 counts of aggravated possession of drugs, both 5th-degree felonies. And I've been presented with a plea of guilty form and entry granting intervention in lieu of conviction and staying in criminal proceedings. However, I just received a fax a couple of days ago indicating that the probation department did not have any information regarding this, and I don't have a report. Were you able to complete the report, Mr. Fulton?
Yes, Your Honor.
Well, I don't have it. I have also a fax here from somebody called Techno Damage. Are you in a treatment program, Mr. Wilson?
Yeah, I'll start next Thursday in Pet Recovery.
Where at?
Mm-hmm. Pet Recovery.
Pay Recovery.
Yeah.
If I may, when we first filed the application for treatment, do you advise the probation department that he's a resident of Fayette County?
I don't have this.
Did you work in to go to Fayette County Recovery Services.
Okay, go ahead, Mr. Trout, sorry.
He can go to Fayette County Recovery Services
Right.
afterward. They did an assessment, I think a few weeks ago, and Shannon can tell me if that's not right. They did not finish it. From my understanding, they were supposed to finish it this morning, and we were hoping that they would get the information to you by this afternoon so that we could go forward. But I believe he's complied with everything as we're required to.
Yes.
Well, let me tell you what I've got from the probation department here. That was faxed to me on the 3rd. Is that he's been marginally compliant under pre-trial supervision. Reported on November 9th with PSI, missed the next 3 out of 4 scheduled appointments. Last person contact was December 3rd, when he walked in after missing a previous scheduled appointment. According to the staff at Fayette Recovery, he missed a scheduled assessment on December 8th due to having the dates mixed up. He was scheduled for an assessment on December 27th. At this time, it's unclear if he made the appointment or not. He's keeping contact by phone, but not in person. Now, I don't have anything from Fayette Recovery. I have Techno Bank, and I have no idea who that is. Are you familiar with them, Ms. Sturgill? If you're still there? She's not there. All right, didn't find the report. Pardon me? All right.
Your Honor, that is what I received from Fayette Recovery. I received the assessment. They were supposed to do the treatment plan this morning.
All right. But we don't have any proof from them that there's actual confirmation of his treatment. Yeah. So we're going to have to continue this matter, Mr. Wilson, and set it out another few days. But let me tell you, I'm a little concerned about your likelihood of success, seeing as how you've been very marginal in applying so far. And so, if you want to take advantage of this opportunity, it's a great opportunity to avoid getting a felony conviction. You better start getting serious about this and keeping appointments and doing things you're supposed to be doing and not getting appointments mixed up, which I think is BS or, that's something I would rather be doing than going to my appointment. So I'm going to continue this matter until January the 20th at 1 o'clock. And you get a hold of Fayette Recovery and tell them we need proof of your enrollment and your compliance. If you're supposed to start, when did you say you're supposed to start?
Thursday.
Next Thursday, a week from today. So, all right, well, you'll need to send compliant proof that you're enrolled and that you're in compliance.
Okay.
You understand?
Yep.
All right. Thank you.
Thank you.
All right.
Okay, that's
We're
all.
done with the jail, right?
No, that's all the bills.
Hmm?
That's all the bill Armantrouts.
Okay.
Now we've got all 6 for Denny at the jail.
Okay, so Bill's done. All right.
Yes, the next
All
one.
right, Deputy, he just signed off. Oh, no, there it is. Okay. Bill signed off and then
Right.
moved the screen. All right.
Samuel McLeese.
Yeah, Mr. McLeese. All right, just case number 20 CR 73, State of Ohio versus Samuel McLeese. And you are Samuel McLeese appearing there from the jail? Yes. All right, the defendant was convicted of possession of drugs, a 5th-degree felony, and was placed on community control on originally on November 13, 2019, and then there were modifications made on August 21st of 2020. On December the 3rd, there was a notification filed that he had violated Rule 1, 2, and 13, and 15. He was notified of that, and Mr. Kirk is appointed representative set for a hearing today. So he's appearing by video or by Zoom in the jail. Mr. Kirk is his attorney appearing by Zoom in his office, and then also appearing from his office as Assistant Representative State Assistant Prosecutor King. Mr. Kirk, you and your client both stipulated to the defendant appearing remotely by Zoom rather than in person in court.
Yes, sir.
And you're agreeing with that, Mr. McLeese?
Yes, sir. If it's getting, I have to speak to Mr. Burke for just a moment.
All right. I'll put you in the breakout right then. All right, just open that room. Should be something that says join. Click on that, and when you're done, you'll click leave.
All the rest of the 1 o'clocks are jail, so they've got that room tied up. 2 o'clock Barger, if she's on
She's
there.
on, yeah.
If any of her clients,
There's Heather Timberlake on it, Austin. We have 2 people that aren't there.
Gabrielle Preston and Ryan Wilson and Austin Goddard.
Yeah, Mr. Pierce, or Ryan,
Ryan Wilson.
Yeah, Ryan Wilson, he's also on. We got so many, yes.
Okay. Preston, Wilson, and Goddard.
Let's go ahead and go on record on Austin Goddard. That was Barber is present.
Okay.
Mr. Goddard, if you would unmute yourself, please. 21 CRP. Okay, case number 21, CR 183, State of Ohio versus Austin Goddard. Hearing being conducted by Zoom, and you're Austin Goddard. Appearing on the screen, it has Austin in the corner. All right, his attorney is Sarah Barber, and representing the state is Assistant Prosecutor King. This hearing being conducted by Zoom. The defendant is charged with breaking and entering and theft and criminal damage. I have received a motion for intervention in lieu of conviction filed on the 4th, along with stipulated questions that indicate that he apparently qualifies for everything for consideration. And so the court will order that the defendant be evaluated and have a pre-hearing report from the probation office, so you can contact Mr. Fulton there at the probation department. He's not on the screen at the moment, but as soon as we get done, you call the probation department, get an appointment set up, see him, there it is, and then also be assessed for substance use disorder, mental health issues. Are you in a treatment program right now?
No,
Okay, where do you live?
I live very close to her.
All right, so you'll be go to the probation department. So as soon as we get done, you call probation and set up your appointment with Mr. Fulton. And then I don't know if there's a trial date or not. I didn't look. Yeah, January 27th. So we'll vacate the trial date and order the evaluation, and we'll set a hearing on this for February 17th at 3 o'clock. Well, let's see. Wait a minute. Is that a Wednesday? No, that's a Thursday. Yeah, that's okay for you, Ms. Parker. I can't hear you, Ms. Parker. 3 o'clock will be all right for you at 3. Okay, 3 o'clock on February 17th. All right. So you get in touch with probation as soon as we get off, as soon as you, leave this, hearing, okay? All right, anything further to council? All right, then you can go ahead and log off, Mr. Austin, call probation, thank you.
Thank you.
Mr. Goddard.
Back to
Okay, we're
McLean.
back on record on the police.
Please, 1 second.
He's back.
On record.
All right, the police, you had an opportunity to get all of your questions answered, discuss with your attorney. All right. Now, you understand the right to hearing? So you understand that if you admit to these violations, then the court could do one of three things. I can terminate your community control sentence you to prison for 26 to 12 months. I can fine you $2,500, and then the other second possibility is I can continue under the same conditions previously ordered. The third is that I can continue with additional conditions I think appropriate, including extending your supervision up to 5 years. You understand that? And has anyone promised you anything or tried in any way to get you to admit to the allegations? And the allegations are that you violated Rule 1, that you have a new DUI conviction in Hillsborough Municipal Court, another one pending. Rule 2, that you failed to report since September 16, 2021, and missed your report on 11/19/21. And Rule 13, you failed to enroll and complete a recommended treatment program as directed by Municipal Court County Probation. And Rule 15, you failed to make any payments on costs. Those are the allegations. You understand the allegations? Okay. Do you have any questions about anything that we've discussed here this afternoon? All right, then are you admitting to these violations?
Yes.
Yeah. All right, anything from probation or state regarding disposition?
Thank you, Your Honor. The state is that the defendant's over your road. And looking at the track record of the supervision, the ATCR still case is officially granted February 19. He admitted to violating the conditions of tax program in October 19, placed on community control. The 20 CR 73 case placed on community control. And looking at my notes, he's told tax program without being last years. Instead of taking advantage of the opportunity to keep the kids, this is regularly on as another recognized candidate. He's not been compliant with the building, no proof to the treatment that he was instructed, and they will have to pay for it. So based on that position of the state, regulation that this is not being used for, and we ask them to be the sense of regulation. Thank you.
We only have one charge there, going to 20 CR 73.
No, there's two cases.
There is. All right, well, hold on a minute, because I think I only have one on the docket. I want to see the one on the docket.
That's all there was that we pulled, yes, Your Honor.
Yeah, it's also on the docket. All right, I'm gonna have to get that file. Okay, what is that case number again?
18 CRs,
I have a 73. Okay, for some reason we only have one of this, Mr. Pleas' cases on the docket. I need 18 CR to a second. All right, I'm going to go ahead and take a recess on that case while they're pulling that file. We'll have to go back and clean up the record a little bit. So I want to go ahead and do Mr. Wilson's case here. Change this over to 21 CR 173, State Mr. Brian Wilson. And Mr. Wilson, if you would unmute your phone there, please. All right, this is case number 21-0173, State of Ohio versus Ryan L. Wilson. This hearing is being conducted by Zoom. Mr. Wilson appearing, you are Ryan Wilson appearing on the screen. It says Ryan's phone.
Yes, Your Honor.
All right, Mr. Wilson's attorney is Dennis Kirk. He's appearing by Zoom in his office. Appearing from the prosecutor's office is Assistant Prosecutor King. The defendant has entered plea of guilty to theft by deception, a fifth-degree felony. Matter was referred for a pre-sentence report. The court has received that report. And each of the attorneys had an opportunity to review that matter for that report. Summary. All right.
Counsel was,
Oh, I'm sorry.
yes.
Thank you, Ms. Barber. All right. Yeah, I was told that Mr. Kirk had 8, and I didn't realize that we still had you on here. Apologize for that. All right. Anything from the state then regarding sentencing? All right, Ms. Barber, anything you'd like to say on behalf of the defendant? All right, Mr. Wilson, anything you'd like to say?
No, Your Honor.
All right. And you're still working in your own business, is that correct?
Yes, Your Honor.
And are you, it looks like you're in treatment at the advanced recovery?
Yes, Your Honor.
All right, and you're compliant with their program at this point?
Yes, Your Honor. I go some groups on substance abuse every Wednesday. I have individuals once every other week with mental health.
Okay. All right. Well, it's the order of court that the defendant be sentenced to a term of 3 years of community control under the following conditions. First of all, you will obey all laws of all jurisdictions and conduct yourself in a law-abiding manner at all times. And then, by the way, you're the supervision of the Highland County Probation Department. You'll be required to report when and as directed, and keep them informed of your residence and place of employment at all times. You may not change either without current permission. You must keep them. You must be truthful in all statements you make to them regarding your supervision. You may not leave the state of Ohio at any time without prior written permission. And instead, you can't change your residence or place of employment without prior permission. You may not enter upon the grounds of any correctional facility or may communicate with or attempt to communicate with anyone who's an inmate in those facilities unless you have prior written permission. You're not permitted to purchase, possess, use, or have under control any kind of firearm, ammunition, dangerous or weapons of any kind. You're not permitted to purchase, possess, use, or have under control any controlled substance, drug abuse, CBD oil, kratom, or any varying analog of any controlled substance that has effects similar to those or drugs of abuse, or any instrument, device, or thing that may be used to administer or prepare that administration unless you have prior legal prescription, copy of which must be provided within 24 hours of receipt. You are submitted to drug testing when and as directed. You may not purchase, possess, use, or have under control any kind of alcoholic beverage or may be present in places being sold or assumed to be otherwise lawful. Not associated with anyone who is a co-defendant, has a criminal record, member of a gang or a criminal group, or any person who has in the past or could in the future unless you commit a violation of the law or these conditions. You may not, after the date of this order, marry or establish a common law type relationship with another person without prior written permission. Thus report any contact with law enforcement or any arrest, citation, conviction, or other charge violating the law not later than the next business day after that occurs. Thus provide your supervising officer with financial information records so your ability to pay any fees or costs of restitution may be reviewed. If you're referred for an evaluation assessment or any kind of treatment, therapy, counseling, training program beyond that report, you're to submit to that. There's a recommendation for programming your enroll in the session to complete that. You pay the court costs of this action, make a payment arrangement to do that. The order to pay restitution, I believe that amount is $3,400. $13.04. And that is payable to Shirley Blevins. And that is ordered to be paid through the victim witness escrow account, and they will you'll pay any fees for charge for that. And you're working full time now, Mr. Wilson?
Yes, Your Honor.
All right. You make restitution payments, so I'm going to set you up at $150 a month beginning February the 1st, and they're on the first of the month after that. And that way you can get it paid within 3 years. But if you don't get it paid, you won't get off paper, and they'll come in and ask to extend your community control. I could make it 5 years. I prefer to make it 3, so that people can get their lives back that are complying quicker. But you do have to get this restitution paid. So push you up on $150 a month. That's about 25 months, or let's say $150 a month would be a little over 22 months, so a little less than 2 years. And if you can make additional payments on that, either use an income tax refund or something like that, the quicker you get it paid off, the better you have a chance to have it getting terminated from supervision earlier than 3 years. Year 2, successfully complete your substance use disorder treatment through family recovery. And any aftercare that they recommend.
Yes, Your Honor.
Now, by being put under community control, rather than being sentenced to prison, if you're deemed consented to a search without a warrant of your person, your vehicle, your residence, or any other property or place where you're found, or vehicle where you're found, which is under your control at any time, any officer of the probation department. There won't be any fine imposed. You're also ordered to pay the court costs. If you fail to do that, then the court could order that to be collected from various things, including levy on bank accounts, wages, earnings, or other assets. If that doesn't collect, then upon completion of that sentence, upon proof of that, then court will order you to be served to give you credit for each hour you work. And then amount of raise up for each hour you work, reduce your judgment by that until paid full. Now, if the probation department feels that you're not complying with these conditions, they will be required to file a red notice letter to the court and serve a copy on it. You'll be entitled to have a hearing, be represented by counsel at that hearing. If the outcome of that hearing is that you have failed to comply, then at that time the court could revoke your community control and then send you to prison for between 6 and 12 months and fine you $2,500. And if that happens, once you complete the sentence imposed by the court, it is possible that the Health Parole Authority would order you to be placed on post-release control supervision for a period of up to 2 years. And if they do, you'll be supervised on the conditions they set, and if they find you have failed to comply, they could return you to prison even though you served the entire term set by the court for an additional period of up to half of your prison term for one or more violations with a felony. An additional member sentenced the judge in a new case imposed upon you, and the judge could also sentence you in this case to an additional period of 1 year, whatever time that on that period of post-release control, whichever is greater. If that occurs, that has to be served consecutively to the sentence in the new case. Now, do you understand all that?
Yes, Your Honor.
All right. Anything further, counsel? All right. You're terminated from community or pretrial supervision now, Mr. Wilson. You're not under pretrial supervision, but you need to contact probation, set up an appointment to report to that. Or do you already have one scheduled?
No, Your Honor.
All right. As soon as we get done here, as soon as you leave here, sign off, call probation, and tell them you just were put on community control, and they'll need to set you up with whichever officer is going to be supervising.
Yes, Your Honor.
All right. Thank you.
Thank you.
All right. Back on record, please. And add to that 18 CR 207. All right, back on record on Mr. Pleas' case. We were on record on case number 20 CR 73, and Mr. King brought up that there was an earlier case as well, 18 CR 207, which for some reason was not on the docket. Apparently didn't get logged in correctly at the clerk's office. And so the allegation of the violation, but he was put on community control for aggravated possession of methamphetamine in that case. And that was on February the 14th, 2019. And then originally, I believe it was under ILC. So, going back to what I explained to you, Mr. Police, I need to apologize for that error. That was somebody's fault here, not yours. So, you actually have two fifth-degree felonies. Probation violations alleged to be violations of both entries in both cases. But instead of just the 6 to 12 months in case number 20 CR 73, if you're admitting to these violations in both cases, then you're also subjected to the same sentence in 18 CR 207, which is 12 months. So that means there's a possible maximum sentence of 24 months plus a fine of $5,000 instead of just $2,500. You understand that? And you understand that if you're admitting to the violation in the 20 CR 73 case, you're also admitting to it in 18 CR 207 case with that penalty. Yeah. I mean, it's not any new violations, it's just that they are violations in both cases. Okay. Yeah, you understand that? Okay, so you understand then that if you admit to these violations or prove that you committed them, then you're subject, if I decided to sentence you to prison, to a term of between 6 months as a minimum, and if I gave you the maximum consecutive, that could be 12 months each, so that could be 24 months. You understand that? All right, does that change anything about what you've decided so far here in your decision? All right, so you're admitting to the violations knowing that it's a violation in both cases. Okay. All right, now, Mr. King, is there anything else you wanted to say before I offer Mr. Hurt a chance to speak?
No, Your Honor.
All right, Mr. Hurt.
Thank you, Your Honor. In regards to the Rule 15 violation of false action, after that violation was filed here very recently, my client, through his own funds that his father applied to the case, has paid off all of his court costs. So to cover his own money, his father's incarcerated, took those funds to court and took care of that. I have support to do. The other thing is there's 2 lower-level felonies, both involving drug possession, both felony buys. So see the next level step would be to continue community control and either send Mr. Police to a residential program or to the STAR program. Violations do not involve any new felonies and primarily center around things related to substance abuse issues involving drugs and alcohol. So, but as we're to continue community control, I understand there's been some issues with community control so far, but I think the issues all center around substance abuse and what we would expect to see somebody struggling with substance abuse. Therefore, either a STAR program or a residential program would be something that would definitely benefit me and I think the fact that we consider in this case. And I think that would definitely help.
All right, Mr. Police, anything you would like to say?
Your Honor, I just want to add that I understand that I'm not able to get the race, but I am making this to everything sorted out, figure out how to figure out how to cost and very much fall short, obviously, this and a lot of people will get a chance to I'm very serious, and I fall short. I like to, I know I'm not I still will, I have one shot to get it right.
Well, one of the violations where you were referred for an assessment, you didn't go. What's going to change here if I give you that chance?
I understand that I still, what happened was, over how I think that and I did that and then figured that I got scared and it just I just never I will really I think good things like I shot a little things, I think things so anyway.
All right. Mr. McLeish, you've been through here for a few times, and it appears that your primary issue is your substance use problem. So, since you haven't committed any felonies, there's no victims of these crimes, I'm going to give you a last chance. I think I said that last time, but that's time to put it. Really, last chance. This is probably the first time I've done that where I ignored my previous statement about last chance, because I see that back in August of 2020, that's what I told you. You did pretty good for a year, and so I'm going to give you this chance, but I can tell you now it's the last chance. I'm going to continue your community control in each case. Your supervision is extended by a period of 2 years. You are to successfully complete the STAR program. There's an event available on January 19th. You will remain in the jail until you're conveyed to STAR. You must successfully complete STAR, and that doesn't mean 90% or 95%. It must be 100% if you don't. And there's no question that if you get kicked out because you were non-compliant or refuse to participate, then you will be going to jail if that's proven. And you'll remain in jail until the bed is available, and you're paying additional court costs on this matter. All right. Yeah, thanks. All right. Who else do we have in jail?
In jail, Jeremy Bender,
Jeremy Bender.
2 cases.
2 cases. I have both of these. I don't know how that happened on another case, I think. They only stuck it in, they'll put it in on the one case.
Yeah, but it might have died by now. It's hard to tell.
All right, are you Jeremy Bender there at the jail?
For the mic. The battery may be dead in it.
Yeah.
We're on the record for Bender, yes.
All right, State of Ohio versus Jeremy P. Bender, case number 20 CR 81 and 21 CR 167. Present on behalf of the Bender, you're appearing from the jail, you're Jeremy Bender. All right, this hearing is being conducted by Zoom, and Mr. Bender's attorney is Dennis Kirk. He's appearing by Zoom from his office, and attorney from prosecutor's office, Assistant Prosecutor King, representing the state. Defendant is charged in 20 CR 81 with aggravated possession of methamphetamine 5th degree felony, and in 21 CR 167 with failure to appear a 4th degree felony. This matter is upon a pre-trial, and I've been presented Mr. Bender in each case with a, well, actually, see, just one case maybe. Okay, 81. Is there a plea just in the one case?
That should be in both.
Oh, there it is. Okay. All right. So I've been presented with plea of guilty agreements in each case, Mr. Bender. The first one is 20 CR 81. I'll hold this up to the camera. You recognize that form as being in this. Whoops, I'm sorry. In this case, plead guilty with your name on it.
Yes.
All right, and on page 3 there are signature lines, and about a third way down on page 3 there's a sentence that says, I enter this plea voluntarily. Immediately below that, there appears to be a signature, Jeremy Bender. I'll hold that up to the camera and ask you if that is your signature on this document. Now, on the other case, 21 CR 167, the failure to appear, that is, I'll hold that up to you. Recognize that document as being pleaded guilty in this case. All right, and on page 3, there's the same sentence. I entered this plea voluntarily. It appears there's a signature, Jeremy Bender. Immediately below that sentence, is that your signature there?
Yes, sir.
Right. Now, before we go any further, Mr. Burke, you and your client both stipulating to having this hearing today remotely by Zoom rather than an in-person appearance by the defendant in court.
Yes, Your Honor.
And you're in agreement with that, Mr. Bender?
Yes.
All right, thank you. All right, now, the agreement in 20 CR 81, Mr. Bender says that you're going to withdraw your not guilty to aggravated possession of methamphetamine under 2925.11 of the Ohio Revised Code of fifth degree felony. Further states that you understand that the maximum penalty for that could be 12 months in prison. The minimum if the prison term is imposed is 6 months. Could be a fine of $2,500 and a license suspension of 6 months to 5 years. In the 21 CR 167 case,
Sure.
decant, please.
I'll come around.
In 167, it says you're going to withdraw your not guilty to failure to appear under 2937.99 of the Ohio Revised Code, also a fourth degree felony. And it says that you understand the maximum penalty for that is 18 months in prison. The minimum would be 6 months as the term imposed, and a fine of $5,000. And if you're convicted in each case, sentenced to prison for the maximum in each case, that would be 18 plus 12, so it could be a total of 30 months in prison and a total fine of $7,500, plus on the aggravated possession of meth charge, it could be a 6-month, 5-year suspension of driving privileges. You understand that? All right. Now, are you facing any felony charges anywhere else, Mr. Bender? Are you currently on probation, community control, post-release control, or parole for a felony? Right, now, under the law, if you're convicted of these offenses, and are sentenced to prison, once you serve the term imposed by the court, it's possible the parole authority, as part of the sentence, may decide to put you under post-release control, supervision for a period of up to 2 years. It's optional. It means they could do it. They may not do it. It's up to them. The judge has no involvement. If they do it, that means that you'll be supervised under the terms they set by a parole officer. If they determine that during that period of time you have failed to comply, they can return you to prison, even though you serve the entire term set by the court, for an additional period of up to 9 months for any one violation, up to a maximum of half of your prison term for all violations. But if your violation is a new felony, then in addition to whatever sentence a judge in that new felony case can impose upon you, that judge could also sentence you in this case for committing that violation while under supervision in this case to an additional period of 1 year, wherever time is left on that post-release control period, whatever is greater. If that occurs, that would have to be served consecutively to the sentence in the new case. You understand that? And you need to speak up a little bit more, Mr. Bender.
Sorry. Yes, sir.
Yeah, just lean forward to the mic. Thank you. All right, now, I'm not required under the law to sentence you to prison for either of these offenses. I can impose what's called community control, meaning instead of going to prison, you can be put under the supervision of a probation officer for a period of up to 5 years under the terms set by the court. If during that period of time the probation department felt that you were not complying, they would notify the court in writing, serve a copy of that on you, and then you'd be entitled to have a hearing and have an attorney at your hearing. If the result of that hearing was that you had failed to comply, then the court at that time could terminate you and sentence you to a total of 30 months in prison and fine you $7,500. You understand that? All right, now the charge in case number 20 CR 81 alleges that on or about February 2, 2020 in this county, you did knowingly obtain, possession, use Schedule 2 controlled substance with methamphetamine. So that's the 5th degree felony aggravated possession of methamphetamine, possible prison term 6 to 12 months, fine $25, and license suspension 6 months to 5 years. Case number 21 CR 167. It's alleged that on or about September 1, 2021, in this county, you recklessly failed to appear if required in Hyde County Common Pleas Court, case number 20 CR 0081. After having been released pursuant to ORC 2937.29, released with protection charge of felony, commission of felony, in violation of section 2937.99. So that's a failure to appear, 4th degree felony, with possible prison term of 6 to 18 months, and fine of $5,000. Mr. Bender, do you understand what it is you've been charged with in each of those cases? What the state said you did, when, where, how they alleged you did it?
Sir, is there any mystery?
Okay. And have you discussed the nature of the charge, the evidence of the case, the possible legal issues of the case, the possible defenses you might try to raise in trial, the possible outcomes of a trial with your attorney?
He's agree with us.
All right, you're satisfied with his advice and confidence in this matter?
He's very, very good. I am. Thank you.
Are you under the influence of any kinds of drugs or alcohol at this time?
I have been single for 1 year.
Okay. Have any threats been made to get you to plead guilty?
No, sir, I just went to school.
All right, now on page 2 of each agreement, there are looks like 3 lines printed in bold and underlined, and then part of those have been stricken out. There are basically 2 options, and so I'll only read the part that's not been stricken out on each document. They read the same, and they read: defendant shall enter plead guilty to the indictment. State defense will argue sentence. That's your understanding of the agreement? No one's promised you any particular sentence if you plead guilty. Right? Now, do you hold any kind of a license or certificate from any state agency that regulates any trade or profession, like a nurse assistant or STNA or barber or anything like that?
I have a culinary arts certification. Other than that,
Okay, that's from a trade organization, though, not from the state, though, right?
it's from the state.
Oh, it is? Okay.
I'm able to still provide work.
Oh, okay. Well, under the law, the clerk is required to notify any licensing board of a felony conviction so that they can determine if that means that there should be any action taken against the licensee or the certificate holder. I can't tell you if it would or would not. I'll just tell you that we have to notify them. You understand that? Okay. Now, you have certain rights you must understand before I can accept the plea guilty. You have a right to have counsel. Mr. Kirk was appointed to represent you not simply to work the case out, but to provide any defense that may be available to you under the law that you would like him to provide. So, if you decide you don't want to do this, he'll still represent you and defend you against these cases, including a trial if that's what you want. You understand that? All right, now, all the rights I'm explaining apply in both cases. You have a right to have a jury trial in each case in which 12 people will be selected from a group of citizens that live in this county that are summoned for jury duty on your trial date. After they are selected, the evidence will be presented. They'll be instructed on the law by the judge, and that jury in each case will decide by unanimous verdict, meaning all 12 have to agree on a verdict in each case as to whether or not the state proved the case. If you didn't want to have a jury trial, but you didn't want to plead guilty, you could waive in writing, and waive in the legal sense means to give up your right to have a jury trial in that particular case, and then you would have a court or bench trial in that case. And what that means is that instead of a jury hearing the evidence, it would be the judge who would hear the evidence. The judge would apply the law, and the judge would decide whether or not the state proved your guilt by proving beyond reasonable doubt. You understand that?
Yes, sir.
All right, now, under the Constitution, Mr. Bender, you have a right in each of these cases to confront the witnesses against you and to cross-examine them through your attorney. What that means is that the witnesses in each case will have to come into court and testify in front of you, your attorney, and anyone else is present. After the prosecutor's done asking questions, your attorney will ask questions. That's called cross-examination. The purpose of that would be to bring out evidence that helps your side of the case. You understand that?
I'm confident, yes, sir.
All right. Now, under the Constitution, you have a right to use the power of the court to compel or force witnesses to come to court to testify for you, just like the state. So, if you decide that you want to have a trial and you have witnesses you're not certain going to come in voluntarily, your request the court would issue a court order called subpoena. That would force those people to come to court and be able to testify even though they didn't want to be here, which is the same way the state's witnesses are required to come to court. You understand that?
Yes.
And under the Constitution, in each of these cases, you have a privilege against self-incrimination, which means you cannot be forced to give evidence at any time during the trial. No one can ever make a testify. The prosecutor can't, the judge can't, you make that decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time. No one's even allowed to comment about it except in one situation, which is if there's a jury trial and you do not testify, the judge instructs the jury that because that's their constitutional right, they cannot consider it for any purpose. You understand that?
Yes, sir.
All right, now, under the Constitution, you are presumed innocent in each of these cases. until proven guilty by the state of Ohio and every essential element of each offense by proof beyond a reasonable doubt. What that means is that the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused. In fact, under law, you don't have to put on any defense in either case. You can, but you're not required to. Whether you do or not, the burden of proof will remain upon the state to prove your guilt by proof beyond a reasonable doubt on every essential element of each offense, which is the highest burden of proof that is known under the law. You understand that? Right now, under the Constitution, when you enter the plea of not guilty to the charge in each case, you deny the allegation in each case, and that charge or that plea then under the Constitution entitles you to all the rights that I just explained. You change your plea from not guilty to guilty. The guilty plea is the opposite of not guilty plea. It says I'm guilty that I did it, and that plea would waive and give up all the rights that I just described for you today, except the right to have an attorney, because you always have the right to have an attorney no matter what you plead. With that exception, you plead guilty, waive and give up. In each case, your right to have a jury or court trial, waive and give up in each case, your right to confront witnesses against you and cross-examine through your attorney, waive and give up in each case, your right to use the power of the court to compel or force witnesses to be in court and testify for you the same as the state. Waive and give up in each case, your right to use your privilege against self-incrimination, because you would be saying you're guilty, that's what you find you guilty. And the way to give up the presumption of innocence in each case, because if you say you're guilty, the state doesn't have to prove you guilty. Also subjects you to being sentenced immediately by the court in each case. And finally, it gives gives up in each case your right to file an appeal of any alleged violations you think may have occurred up to this point in the case. Now, if you are sentenced to the maximum sentence in either case, or if you are under certain circumstances, you could file an appeal. That will have to be filed within 30 days of your sentencing entry being filed. You understand all that? And are you a U.S. citizen, Mr. Bender? And did you enter into these agreements voluntarily? And is it your decision to go forward then and plead guilty in each case pursuant to the terms of the written plea offer we just went over? Do you have any questions you need to speak with your attorney about before we go any further?
No, except thank you, Mr. Kirk, for all your advice and your help.
Okay, do you have any questions at all about what's happened so far here today? All right, and as to the charge of 20 CR 81, which alleges that on or about February 2, 2020, in Miami County, Ohio, you did knowingly obtain, possess, or use a Schedule 2 controlled substance methamphetamine in violation of Section 2925.11 of the Ohio Revised Code of 53 felony, bearing possible prison term 26 to 12 months, fine of $2,500, and possible license suspension 6 months to 5 years. How do you plead? And as to the charge in 21 CR 167, alleges on or about September 1, 2021, Miami County, Ohio, you did recklessly fail to appear as required in Miami County Common Pleas Court case number 20 CR 0081 after having been released pursuant to RC Section 2937.29, released in connection with the charge of commission of felony, violation of Section 2937.99, failure to appear, a 4th-degree felony carrying possible prison term between 6 and 18 months and a fine of $5,000. How do you plead? All right, thank you. Court finds on this day in open court, defendants advise of all his constitutional rights and made no intelligent voluntary waiver of those rights pursuant to criminal 11 in each case. Pleas are accepted and ordered filed in each case. Defendants found guilty of the charge in the indictment in each case. In 20 CR 81, a 5th-degree felony, aggravated possession of methamphetamine, and 21 CR 167, failure to appear, 4th-degree felony. Court orders a pre-sentence report be prepared, bond be continued. The report shall include an assessment for substance use disorder treatment and/or mental health assessment. Sentencing will be set for February the 27th at 1 p.m. All right. Anything further, counsel?
Mayor.
All right. Thank you.
Okay.
All right. Who do we have next?
Chase Jones, 2 cases.
All right. Is that the last one in here?
No.
Okay. Burden, right? Peterson, Reddy's here, and have their own questions on them. Then we'll take those away and give all that stuff going. All right, are you Chase Jones?
Yes, sir.
Okay. All right, this is case number 21 CR 53 and 21 CR 189, both State of Ohio versus Chase Anthony Jones. Mr. Jones is appearing by Zoom from jail. His attorney is Dennis Kirk. He's appearing from his office by Zoom. And then representing the state is Assistant Prosecutor King from his office. Let's see. Case number 21 CR 53. The defendant of Pleas pleaded guilty. Yeah, he pled guilty on looks like on August 19th to a charge of receiving stolen property for fourth-degree felony. And then the matter was set for a sentencing hearing on the 22nd of September. Then it did not appear, and the case was issued. In case number 21-0189, the defendant was indicted on November 2nd for failure to appear, and the matter is set for trial February 7th. This is the first pre-trial. All right. Now, where do we stand on the second charge, counsel? Well, first of all, you're both in agreement to this being conducted by Zoom rather than in person, Mr. Kirk?
Yes, Your Honor.
And you're all right with that, Mr. Jones? Yes, sir. All right. Now, is discovery completed in the second case?
Your Honor, it is not. I erroneously, because I've already represented him in the 53 case, missed the new chick case, so I did file discovery today.
Okay.
It's going to be pretty straightforward since it's a failure to appear. So I did file that today.
All right. Well, we have a final pretrial on the 19th, so I'll go ahead and continue the sentencing in the other case that day, and then we'll see what happens then. All right. Anything further from counsel?
No, Your Honor.
No, Your Honor.
All right. Thank you. All right, you can go ahead and leave Mr. Jones and send in the next
Jacob Wright.
person, Mr. Ryder, to leave.
Your Honor, I will be right back in 1 second. Someone's knocking on the office door, just so I can let them in. They're here for an appointment here in a few minutes.
Now, make them show them your wallet first before I let them in. If you're not bringing any money, you don't want to see it, do you?
That's right.
Someone's knocking at the door.
All right, case number 21, CR 128, State of Ohio versus Jacob Wright. Are you Jacob Wright, appearing from the jail?
Yes, sir.
Okay. This hearing is being conducted by Zoom. All right, Mr. Wright's attorney is Dennis Kirk, appearing by Zoom from his office, and Mr. King, representing the state, appearing by Zoom from his office. Mr. Kirk, you and your client both agreed to this sentencing hearing being conducted pursuant to remote Zoom platform, whether it's in person presence at the Courtroom?
Yes, Your Honor.
All right. The defendant has entered a plea of guilty to aggravated possession of drugs, a third-degree felony. The matter has been sent for hearing today on sentence. The court did order a pre-sentence report, and I have not looked at that, so I'll take a real quick look here. Have each of the attorneys had an opportunity to review a summary?
The state has your own.
I did, Your Honor.
All right. All right, anything from the state regarding sentencing?
Thank you, Your Honor. The state is requesting that the defendant be sentenced to a term of incarceration. This is the defendant's 5th felony conviction. He has 2 prior convictions for illegal assembly and also a prior conviction for possession of methamphetamine and also possession of cocaine. This defendant has had multiple opportunities at probation and treatment in the past and has been unable to comply each time. 2007, he was granted treatment in lieu of Clinton County. 2009, had that revoked and was placed on community control, ordered to complete STAR. A year later, he had that community control revoked. In 2013, he was placed on community control out of his favor. 1 year later, had that revoked and was sentenced to prison. 2015, he was granted judicial release, and then a year later, violated and was returned to prison. And looking at the current charges, this defendant also has charges and warrants in multiple courts right now. Oakland Municipal charge there, Clinton County Municipal charges and a bench warrant, Airborne Municipal, Montgomery County Municipal, bench warrant there. And looking at facts of the case that was before the court today, the drugs were discovered following a traffic stop, and the defendant identified himself to law enforcement as his half-brother. Actually, he gave his half-brother's social security number. That led to an OBI charge actually being filed in the municipal court against the wrong person, which was obviously quickly dismissed. So based on all that, Your Honor, it is the position of the state that this defendant is not amenable to community control but has to be sentenced to a term of incarceration. Thank you.
All right, Mr. Kirk.
Thank you, Your Honor. I believe his last felony was either 2013 or 2014. I know there was a violation, but there's been no new felonies in quite a while until now. In this case, before the court, the facts could obviously have been a lot worse. So when I look at the facts, they're not as serious as other cases. He didn't flee or anything like that from law enforcement. Yes, he did lie to them, but he did not flee or take off or assault a police officer or anything of that nature. Drugs have been a long-standing problem here. And when I met with Jake in jail, he really reached a point where he told me that he's got to change his behavior. And he seemed very sincere to me that he wants to enter treatment and get this ship righted, because it's obviously not working out in the way it has been. He wants to break the cycle, is what he told me. And I think that he's at a place now where he wants to do that. So I think he'd be more amenable to treatment than perhaps in the past. He has successfully completed treatment in the past. He's just done things to violate when he gets back on drugs again, which is typical of what we would expect to see with somebody who's struggling with substance abuse. the warrants that were mentioned, I think some of those have occurred because Mr. Wright has been incarcerated on this case. Some of the misdemeanor courts have not asked that he be brought before the board again, so he's picked up some warrants there. I think those are things he can definitely get behind him. My understanding is there's a counseling center bed available here in a few days on the 7th, and that if the court felt that was not appropriate, felt Star was appropriate, there's even a bed at Star available as well. So we would ask the court to grant community control in this case, and any appropriate treatment the court would deem necessary and fit for Mr. Wright to enter into.
All right, Mr. Wright, anything you'd like to say?
I know I've had some struggles in the past. I know when I first grade, I really didn't. I don't think the timing was right. I don't think I was taking things as serious. But when I came home from prison, when I was in prison, when I violated and got sent back to prison, I began taking things more serious. When I came home from prison, I stayed clean for 18 months. Working, got my family back together. Feeling really good. Still unsure of what happened and where I went wrong. I think I was just not working proper steps, working a program, not going to meetings, stuff like that. So I ended up relapsing, and it's taken me up until now to get my head back on straight. I'm definitely ready to do things different this time. I appreciate getting the chance to do treatment.
Your Honor, I forgot to add too, we discussed in a matter that was mentioned to you, a drug court. I think this would be a very good case for drug court. It kind of fits the mold of what drug court was designed to do. So we asked the court to also consider drug court as an option.
Well, I do have a letter from Ms. Sturgill indicating she has screening but found he meets the criteria. The court decides to have him on the drug court docket. Mr. Wright, have you assigned a request to be admitted into the drug court? Okay, yeah, here it is. It's in there before the letter. I'm sorry. All right. Yeah, I understand this is something that's voluntarily on your part. The court doesn't force people to drug court because if it does, it's less likely that they'll complete it. It's kind of like STAR, or kind of like community control. You're going to try to stay out of prison. Whereas the drug court focuses on the person's desire to become sober, remain sober, and change their pattern of life and deal with that and recovery. And the focus is on the recovery as opposed to simply staying out of prison. And because what we found is that people do have a sincere interest in staying sober, there's a much better chance that they won't commit a crime. So I do have your application. Is that something that you're still interested in?
Yes, sir.
Well, if you want to be in the drug court simply because you want to stay out of prison, then you're wasting your time and everyone else's time. We've had a couple people who, we've let in who that's exactly what their motivation was, and didn't work out very well. Those kind of people usually get washed out pretty quickly. So that's the real question here, because you have had a bad track record, and you have had opportunities for treatment. You've been through STAR, but you continue to commit these crimes. But if that's is that what you want to do?
Go for it, yes, sir.
Well, Mr. Ryder, I'm going to give you the chance. And I can tell you that you're going to be on a short leash. And you need to understand that. Because I'm not real optimistic that you're going to complete. But it's a third-degree felony, and if you don't complete it, you're probably going to get most of the 36 months that's available, between 9 and 36 months. So that's going to be the idea here, because if you're just doing this to try to stay out of prison and continue to skirt the rules and stay high, that's going to catch up with you. You're going to be tested 3 times a week for the first few weeks, and at least twice a week for a long time, and maybe more often than that. If you test positive, there's consequences. Don't get kicked out immediately, but there are consequences. But if it continues, you can't get kicked out and get sent to prison. You understand that?
Yes, sir.
All right. Well, the court then will order the defendant be admitted into the drug court docket at his request, and finding that he does meet the criteria. And it's the order of the court that the defendant be placed on 3 years of community control supervision on the drug court docket. Under these, well, first of all, you comply with all those conditions that are in the handbook and the program restriction that you sign, that you previously signed and filed with the court, and you comply with all those conditions, and I will also go over these conditions. First of all, your bail law of all jurisdictions, protects yourself from all violent matter of time. Court will then directly be true from all statements and make information part of your supervision. Keep it informed of your residence, place of employment all the time. Do not change either without prior permission. You may not leave the state of Ohio at any time without prior written permission. You may not enter upon the grounds of any correctional facility, nor communicate with, attempt to communicate with anyone who's an inmate in those facilities without prior permission. You are not permitted under federal law for several convictions to possess, own, use, or have under your control or purchase any kind of firearm, ammunition, or dangerous ordinance. If you do that, it's a violation of federal state law. It could result in you convicted of new felonies in a sense. It's also a condition you not have any of those or any other type of weapons while you're on community control in drug court. You're not permitted to purchase, possess, use, or have under your control any kind of a controlled substance, drug abuse, CBD oil, kratom, any variant or analog of a controlled substance, drug abuse that has effects similar to those, nor any instrument, device, or thing that may be used to administer drugs for present administration unless you have a lawful prescription. And if you do, you must provide a copy of it within 24 hours of receipt. You're not permitted to obtain a medical marijuana card while in the drug court docket. You're to submit to testing when and as requested by the probation department or any member of your treatment team. You're not permitted to purchase, possess, use, have under control alcoholic beverages, nor may be present in places of the soul being consumed, even otherwise lawful. Not to associate with anyone who's a co-defendant in this case or any other person has a criminal record, member of gang or a criminal group, or any person has a past to the future, unless you commit a criminal offense to violate these conditions. Must approve the writing by your supervising officer. It also applies to any family members that may fall within that definition unless you're living with them immediately before this offense is committed. After the date of this order, you may not marry or establish cohabitation or common law marriage type relationship with another person without written permission. You must report any contact law enforcement, any arrest, citation, conviction, or other charge violating the law not later than after business day after that occurs. Must provide your supervising officer financial information records so your ability to pay the fines, fees, and costs of your duty. If you're referred by the probation department or your probation officer or any treatment team member for further evaluation assessment for any kind of treatment, therapy, counseling, training, etc., to submit to that. If they recommend any further programming, you're to roll in to complete that. You're going to pay the court costs of this action, make arrangements to do that. You'll remain in the jail until you're conveyed to treatment. You will be required to comply with all of the requirements and conditions set forth in the new waiver for recovery drug court docket, which you have provided to you and incorporated by reference. And you're complete to comply with your treatment plan as they recommend. Not as you choose, but as they recommend. Now, by being placed under community control, rather than be stated and being sentenced to prison, you're deemed consented to a search without a warrant of your person or residence or vehicles owned by you, used by you, or any other property place that vehicle where you're bound or under your control anytime any probation officer. The court will not impose any fine or driving suspension. The court costs are also ordered as a substantive order, so if you don't pay payments on those as a required, clerk can collect that through various means, including levying bank accounts, wages, earnings, and other assets that you may have. If that doesn't collect it, then the court for you to service and give you credit for each hour of work. In an IRS that of court in each hour of work will reduce your judgment amount to pay full. Now, in the event that it's alleged that you have failed to comply with these conditions, the adult parole authority will file a written notice of that with the court, provide you a copy, and you'll be entitled to have a hearing. You'll be represented at that hearing by counsel, and the outcome of that hearing is that you have failed to comply. Then at that time, you will be terminated from the drug court, transferred back to regular docket, and will be sentenced to a term of between 9 and 36 months, and fined $10,000. Now, in the event that that happens, then it is possible once you complete your sentence that the adult parole authority at their option will put you under post-release control supervision for a period of up to 2 years. If they decide to do that and you fail to comply with those conditions, they can return you to prison, even though you served the entire term set by the court. an additional period of up to 9 months for any one violation, although there is a cap of half your prison term for all violations of the community felony. And an additional whatever sentence the judge in the new case can impose upon that judge also authorized sentence. In this case, the additional period of 1 year, whatever time left on that period of post-prison control, whichever is greater. If that occurs, that must be served consecutively with the sentence in the new case. I'm going to order that your treatment be at the counseling center, and I believe, is that been available tomorrow, Ms. Sturgill?
Yes, yes, sir.
All right. I'm not just saying to start. I want to focus on your substance abuse problem because that's your primary issue, and so you'll be required to go to the counseling center, and that'll be January the 17th. So you can be released. I'm sorry, 7th. So you'll be able to be released tomorrow to their custody, and you'll be required to remain in jail until. All right. Anything further from counsel?
No, Your Honor.
No, Your Honor.
All right. Thank you.
Thank you.
All right.
Jeremy Purdom.
Jeremy Purdom. All right. See you in custody.
Yes, sir. Got one more after him in custody. Here's a note Marcia gave me about the address that one of them is going to log in under, or from somebody's phone. She's a couple of cases down. On the
All right.
record.
Are you Jeremy Purdom there at the jail?
Yes, sir.
All right. Mr. Purdom is case number 21 Sierra 129. Dave Hyde versus Jeremy Charles Purdom, charged with stolen, receiving stolen property. Hearing is being conducted by Zoom. He's appearing in front of the jail, and he's being represented by Dennis Kerr, who's appearing by Zoom in his office, and appearing by Zoom from the prosecutor's office, Assistant Prosecutor King, representing the state. Defendant's charged with receiving stolen property. This is the final pre-trial, and I think he's scheduled for trial later this month, January 24th. All right, where do we stand on this case, counsel?
Your Honor, this case originally was set for first pretrial on December the 15th, I believe, and then had to be continued. So we've actually never had a pretrial on this case.
Oh, okay.
So we would ask to have a second pretrial set and then move the trial date if possible to line it all back up. And I'm currently in discussions with my client and the state of Ohio as to whether it will be resolved or not.
All right, so you're requesting, let's see, today is the 6th, trial date is the 24th, but there are actually three trials on the 19th. So you're requesting a continuance of the trial date?
That's correct.
And your client in agreement with that, waiving time?
He is. We discussed it at the jail earlier this morning.
All right, Mr. Purdom, you're not being held on this case, are you?
No, sir.
Okay, what are you in jail for?
Resolving misdemeanor, municipal matter.
Okay. All right, so your speedy trial in this case is 270 days from the day you were arrested. If you spend any time in jail on this case, you would count 2 or 3 for 1. But I know you're not been held, I don't think, at least since you've been in front of me. And so I think we still have plenty of time. But anytime there's a continuance of any trial date or other hearing at the request of the defendant, then that requires that they waive the speedy trial time. And so we would continue this matter for probably 30 days or so as far as the trial date is concerned, and continue and set up another pre-trial. It's not your fault because of the circumstances on a personal issue resulted in the first pre-trial being vacated. So if you're in agreement with that, waiving time and understanding waiving time before we'll grant that continuance.
Yes, sir.
All right. All right, when the court then will set grant continuance, extended speedy trial time, pursuant to 2945.72H, set the final pre-trial for January the 19th at 2 o'clock p.m. and we'll extend the trial date to February 22nd at 8 a.m. Now, if you, are you serving a sentence on a misdemeanor, or are you just being held to disposition? All right. Well, in the event that you are released, you report to probation immediately upon your release, because I have a report from them that your last contact with them was on November 24th, and you had a female call in and say you tested positive for COVID. The one was rescheduled, no call, no show, and then there was a warrant out of municipal court prepared to appear. So, make sure you report. If I get a report you didn't report, you're not reporting, probably going to issue a warrant for you and you held in jail until I have a further hearing to determine if you're going to be able to appear at trial, since you didn't appear already once in municipal court. You don't want to have to go running around looking for you again. So, get out of jail on your misdemeanor, you see the probation department immediately. Not at your convenience. You go directly to jail to the probation department. You understand? All right. All right, thank you. Okay. Jonathan Peterson.
Jonathan Peterson.
All right, Jonathan Peterson. All right, are you Jonathan Douglas Peterson, appearing from the jail? All right, this is case number 21-0174, State of Ohio versus Jonathan Douglas Peterson. This hearing being conducted by Zoom. Mr. Peterson appearing from the jail. His attorney's Dennis Kirk appearing from his office, and appearing from the prosecutor's office representing the state is Adam King. Defendant charged with 2 counts of rape. Matter for the court is a report on the defendant's competent stand trial, which was completed November 29th. The matter was set for a hearing that had to be continued due to a family situation and on the part of the judge. And so this is the hearing today on that issue. Have each of the attorneys had an opportunity to review the report from Dr. Deborah O'Donnell, PhD.
They have some.
Do either of the parties wish to present any additional evidence regarding this matter?
Nothing from the state.
Sure. All right, and then based on the report from the Dr. O'Donnell, the date of the report is November 29th. It's her indication that the defendant is capable of understanding the nature of objective proceedings, assisting in defense, and it's recommended that he be found competent to stand trial. So that is the order of the court. Also note that the report at the direction of the court as to mental state at the time of the alleged offense, and there's an indication in the report that Dr. O'Donnell as well, that there will be no, that was dated December 4th, that there is no basis for supporting a file for that purpose. All right, so with that, court, I think we've had one pre-trial in this case already, gentlemen.
I believe on October 20th.
All right. Okay, we'll set the next pre-trial, final pre-trial, January the 19th, 1 o'clock. And the trial will be set for February 22nd at 8 a.m. Cases restored to the active docket, and the speedy trial time is extended total until February the 22nd due to the proceedings to determine his competency to the attorney. Anything further from counsel?
No, you're
All right, thank you. All right, Gabrielle Preston.
Yes, Your Honor.
All right, case number Stablehouse versus Gabrielle E. Preston. Preston, you're appearing on the screen that has Heather Timberlake in the corner.
Yes, that's my counselor, sir.
All right. This case is being, hearing is being conducted by Zoom. Ms. Preston is appearing. Where are you appearing from?
I am in treatment. I'm at Ascend Counseling in Portsmouth, Ohio.
Okay. All right. Appearing on behalf of the defendant is Attorney Sarah Ryder, her office, and appearing from the prosecutor's office on behalf of the state's Assistant Prosecutor King. This is a matter before the court for sentencing. The defendant entered a plea of guilty to aggravated possession of a fentanyl-related compound, a fifth-degree felony. Court ordered a pre-sentence report, and I have had that prepared. I will admit that I have not had a chance. I'm still trying to catch up the last month, so I did not get a chance to review that yet there, but I will shortly. But each of the attorneys had a chance to review a summary.
Hey, guys.
Okay. And you said you're at Ascend in Portsmouth? Where'd she go?
It looks like she got disconnected.
Okay. Dr. Dropper. All right, well, while we're waiting on her to reestablish, I'll have them call her counselor. We'll go ahead and do Mr. Rippey. So I'll change this over to Mr. Rippey. All right, she dropped a call, Mr. President, counselor, so we call down her to Ascend. And Heather Timberlake is the counselor's name. So I'll let her tell them to call back in. They dropped. All right, case number 15, CR 67, State of Ohio versus John Rippey. You're John Rippey?
Yes, sir.
All right, this is a hearing on sealing of a record pursuant to section 2953.32 of conviction. Oh, this doesn't need to be on. So let's go ahead and stop that. And tell Marcia to mark that right.
He has, Your Honor.
Yes, Your Honor.
All right, anything from the state regarding sentencing?
Only was containing the plea agreement, Your Honor.
All right, Mr. Ryder?
Just what's contained in the plea agreement, Your Honor. She is in treatment. She has been continuing with her treatment since she's gotten to resent.
All right. Anything you would like to say, Ms. Preston?
No, I just really want this, and, taking my kid back and getting a job in the car. I have goals and I'm gonna attain them.
All right. Well, you know, see that you had been in intervention once before in treatment in Adams County and was discharged on September the 15th of 2020, and then fortunately 6 or 8 months later, then he ended up with this second situation, which I'm sure was a relapse. But you are in treatment, and the reports from the SAM do indicate that you are compliant. So the court, if it does grant your, or does hereby sentence you to a term of 3 years of community control supervision under these conditions. First of all, you obey all laws, all jurisdictions, conduct yourself in all abiding manner at all times. Must report when and as directed, be truthful in all statements you make to the probation department regarding supervision conditions. You must report, you must keep them informed of your residence and place of employment at all times. You may not change either without prior permission. You may not leave the state of Ohio at any time without prior written permission. You may not enter upon the grounds of any correctional facility or may communicate with, attempt to communicate with anyone who is inmate or resident in any of those facilities without prior written permission. You are prohibited under both federal and state law from purchasing, possessing, or using, or having under your control any kind of firearm, ammunition, or dangerous ordnance. If you do that, then you can be subject to being prosecuted for a felony under either federal or state law or both, and being subject to being in prison unless you have that disability removed in a future legal proceeding. It's also a condition for your community control that you not have any weapons of any kind, including those. You're not permitted to purchase, possess, use, or have under your control any kind of controlled substance, drug abuse, CBD oil, kratom, or any variant or analog of any controlled substance or drug abuse that has effects that would be similar to those substances. Nor may you have any instrument, device, or thing that may be used to administer drugs or prepare them for administration unless you have a prior legal prescription, copy of which must be provided to your supervising officer within 24 hours of its receipt. You are submitted to drug testing when and as directed by probation or any treatment provider. You may not purchase, possess, use, or have under your control any kind of alcoholic beverage, nor may be present places where the soil will be consumed, even if otherwise lawful. You're not permitted to purchase, possess, use, or have under your control any alcoholic beverage, nor may be present places where the soil will be consumed, even if that is otherwise lawful. You're not to associate with any person who may have been a codependent in this case, if any, or any other person who has a criminal record, as a member of the gang or the criminal group, or any person who has some past or future, unless you commit a criminal offense to violate these conditions, unless that is approved in writing by your supervising officer. You may not, after the date of this order, marry or establish cohabitation or common law marriage type of relationship with another person without prior written permission. You must report any contact with law enforcement or any arrest, citation, conviction, or other charge of violating the law not later than the next business day after that occurs. You must provide your supervising officer with financial information records so your ability to pay any fees or costs can be reviewed. If you are referred by the probation department or any officer of the probation department for evaluation assessment, any other treatment, therapy, counseling, training, or other education program on that approved by the court, then you're to submit to that. If they recommend any kind of programming, then you are to enroll in and successfully complete that. To be required to successfully complete the substance abuse disorder treatment that you are currently undergoing residentially at the SEN, and any aftercare that they recommend. Now, by being placed on community control rather than being sentenced to prison, you're deemed to have consented to a search without a warrant of your person, your residence, or any vehicle that is owned by, used by you, or any other property place that is under your control or where you're found at any time by any officer of the probation department. There'll be no fine, no driving suspension imposed. You are ordered to pay the court costs and make payment arrangements to do that as a condition. And if you don't do that, it's also a simple order. If you don't do that, the clerk will collect that through various means, including levying on bank accounts, wages, earnings, or other assets that you may have. If that doesn't collect it, then the court could order you to do community service, give you credit for each hour you work, and then IRA 7 before each hour you work, reduce your judgment by that amount until paid in full. Now, in the event that the probation department feels that you have failed to comply with these conditions, then they can file a written notice of that with the court. You'll be served a copy of that. You'll be entitled to have a hearing and have an attorney to represent you. If the outcome of that hearing is that you have failed to comply, then the court at that time terminates you from community control and sends you to prison for between 6 and 12 months and fine you $2,500. If that occurs, once you complete the sentence ordered by the court, it's possible that the parole authority may, at their option, put you under post-release control supervision for a period of up to 2 years. If they do, again, it's optional, it's not mandatory, but if they do, you'll be supervised under those conditions by the parole officer. If they determine that you failed to comply, they can return you to prison. They can serve an additional period of up to half of your prison term for one or more violations. But if you are convicted of a new felony while under post-release control supervision, then whatever sentence to be imposed in the new felony case by that judge can also sentence you to an additional period of 1 year, whatever time left on that 2 years of post-release control, whichever is greater, for committing that offense while under supervision in this case. And that will be served separately to the sentence in that case. All right, is there anything further from the council?
There.
All right, Ms. Preston, this terminates your pretrial supervision, so you're not under those conditions anymore. But does she need to call the office to set up an appointment for an interview, Mr. Argina?
Yes, Your Honor. Call the same number. Just hit 108 at extension.
All right, go ahead and call them as soon as we hang up here so we can get that set up. All right?
Thank you.
All right, thank you. Okay, it's a long stay at home for a while.
I didn't know
I'll take a nap.
if your voice was going to hold out there. I don't know how you can remember to tell all those people those things.
You know what? The mouth has muscle. My mouth and brain have muscle memory too. Oftentimes, I just set that on autopilot. I'm talking while I'm reading something, just trusting my mouth and brain is going to tell the right thing. Most of the time, it works. Once in a while, I get distracted when I'm reading something, but I always seem to realize I missed something and go back and fix it. Yeah, that's I've said those things so many times that I don't even have to think about it.
Wake up in the middle of the night.
We're off, you too,
Pardon?
We're off everything.
Hang on a second.